Good afternoon. My name is Rachel Iskov, and I am the League for Human Rights Hamilton Family Fellow. The League for Human Rights has given me a fellowship for my research on familial resistance in the Lodz Ghetto. And I am here to welcome you all to what has become an annual joint League for Human Rights of B'nai Brith Canada and Law Society of Upper Canada event on National Holocaust Memorial Day, or Yom HaShoah. This day, the 27th day of Nisan on the Jewish calendar, is dedicated to the lives and heroism of Jewish people who died in the Holocaust between 1933 and 1945. We thank the Law Society, its treasurer Thomas Conway, the benchers and members for dedicating their resources to marking this day and their ongoing efforts to promote diversity, equality, and respect. On April 22, 2004, Convocation passed a motion that the Law Society's Equity and Aboriginal Issues Committee and the Law Society's Government Relations Committee recommend to Convocation for Convocation's approval the role the Law Society should play and the positive steps it should take to discourage anti-Semitism and all forms of hatred or discrimination based on religion in our profession, our society, and the world, and to promote religious respect for our profession, our society, and our world. A working group was struck, which just so happened to include Mark Sandler, our moderator for today, and this event was the result of the direction set then. After the panel discussion, everyone is invited to join us in the Barristers' Lounge for a reception that will follow. I'll now turn matters over to our moderator, Mark Sandler. Mark Sandler received his LLB from the Faculty of Law, University of Toronto, and is certified by the Law Society as a specialist in criminal law. He is a fellow of the American College of Trial Lawyers, a bencher of the Law Society of Upper Canada, and currently chair Appeals Panel and Tribunals Committee. He is also chair of the Law Foundation of Ontario. His practice is primarily devoted to appellate and trial criminal litigation. He has served as counsel for 6 commissions or reviews, skimming, because this is quite a lot of stuff here. Counsel to... I
don't need to hear it, so you don't have to read it.
Skim a little bit. He has served as a member of the Criminal Law Specialty Committee, Law Society of Upper Canada, Specialist Certification Program as an adjunct professor at Osgoode Law School from 1992 to 2005. Previously co-chaired the Criminal Lawyers Association Annual Convention and educational program for 3 years, and has written and lectured extensively on criminal law evidence, procedure, and advocacy. He co-authored with Honorable Madam Justice F. Weinberg, Criminal Procedure, Cases, Notes, and Materials. He has served as a faculty member for the National Judicial Institute and currently serves as a faculty member of the Federation of Law Society's annual criminal law program. He's formerly a part-time member of the Human Rights Tribunal of Ontario and is former national chair and former senior counsel, B'nai Brith League for Human Rights, and as such has appeared before the Supreme Court of Canada on issues relating to hate propaganda and hate-motivated crime. So with that, let me call him up. Thank you.
Thank you. Thank you for that overly generous introduction. I can't wait to hear what I have to say. Well, welcome everyone. Delighted to see so many people here today to commemorate Holocaust Remembrance Day of 2013. We've got a very, very special program for you today, and so I'm not going to take too much time in my introductory comments. Suffice it to say that we have assembled the foremost experts to address a topic of importance and interest, and that is the interplay between the law and the Holocaust and related events. And our topic will spin a little bit off that topic to what is happening currently throughout the world, but you'll see that as the focus point of our discussion today. Before I introduce our panelists, I want to acknowledge Dr. Mario Silva, who's here, and he'll be more formally acknowledged after our presentation here. He is the chair of the International Holocaust Remembrance Alliance. I also want to acknowledge, I see the Honorable Monty Quinter is here, the MPP for York Centre, and Kostas Menegakis, MP for Richmond Hill. Thank you for coming. It's very, very much appreciated. And I also want to acknowledge so many of my dear friends that are here not to hear me, but are true champions in the fight against Holocaust denial and in support of Holocaust education in Ontario and across Canada. Delighted to see you here. Brings back very, very fond memories of my days as the national chair at B'nai Brith. So, without further ado, let me introduce our panelists. I've done that as if I'm introducing them at the dating game, but nonetheless, here they are. To my immediate left is Oral Braun, who is visiting professor, Department of Government at Harvard University. He is also professor of international relations and political science at the University of Toronto. He has published extensively on communist affairs and strategic studies, and he particularly focuses on the problems of the transformation of the socialist systems in the former Soviet Union and in Eastern Europe. He is the author, editor, contributor in too many works to repeat. I should say that the more extensive biographies, even those don't do them justice, but the more extensive biographies are available to you. I'd rather hear them speak than hear me speak, so you can read more about them by picking up those materials outside in the hall. To his immediate left is Dr. Valerie Hébert. She is the assistant professor in the Department of History and Interdisciplinary Studies at Lakehead. She teaches world history, 20th century European history, and the history of the Holocaust. Her research focuses on transitional justice processes, trials, tribunals, truth commissions that help foster the transition from war and violence to peace and stability. And her book, Hitler's Generals on Trial, The Last War Crimes Tribunal at Nuremberg, was published in 2010. She's also the co-founder of Free the Slaves Canada, an NGO dedicated to raising awareness of and developing programs to combat modern slavery. To her immediate left is David Diesenhaus. David is a professor of law and philosophy at the University of Toronto and a fellow of the Royal Society of Canada. He has taught everywhere, but he holds a doctorate from Osgoode University and law and undergraduate degrees from South Africa. In 2002, he was the Law Foundation Visiting Fellow in the Faculty of Law, University of Auckland. He is the author of Hard Cases in Wicked Legal Systems, South African Law in the Perspective of Legal Philosophy, and a series of other books including Legality and Legitimacy, Carl Schmitt, Hans Kelsen, and Hermann Heller in Weimar, and Judging the Judges, Judging Ourselves, Truth, Reconciliation, and the Apartheid Legal Order. To his left, at the end of the podium, is Lorraine Weinrib. Lorraine was appointed to the Faculty of Law and the Department of Political Science in 1988, and that's at the University of Toronto. Previously, she worked in the Crown Law Office Civil at the Ministry of the Attorney General here in Ontario, holding the position of Deputy Director of Constitutional Law and Policy when she departed. She teaches first-year constitutional law as well as advanced courses on the Charter, constitutional litigation, and comparative constitutional law. She too is a well-published author. Her current work focuses on the legitimacy of the post-World War II model of judicially enforced rights protection, of which Canada's Charter is an example and a model for other countries' constitutional development. She's also published essays on the special contribution that the Canadian Jewish community has made to the protection of rights in the lead-up to the adoption of the Charter. Wow, what a group. Now, I'm the heavy in this dialogue because I've told them that they have relatively limited time to describe their life work to you. So what we hope to do is have each of them spend about a dozen minutes or so answering a very general question that I'm going to put with perhaps some follow-up and then hopefully some time for some exchanges with the members of the audience and perhaps with each other. And perhaps I'll ask them for their initial presentation to do it up here in the podium, and then to respond to any questions from their seats. So, Valerie, I'm going to start with you. If you'd be so kind as to provide us with the historian's perspective on how democracy went off the rails in Germany in the 1930s and the rise of Nazi Germany. That's a 12-minute topic, wouldn't you say?
Thank you very much for the kind introduction. I'm very pleased to be here and speak to you all. Yes, to answer that question that large and that broad in 12 minutes is indeed a challenge. You know, as the historian, I am here to talk to you a little bit about the context in which Adolf Hitler's seizure of power came about. And I thought to do that best would be to give you some idea about the political culture in Germany during the late 19th century and early 20th. And in doing this, I'd like to pose two questions as a way both to focus our inquiry, but also perhaps to problematize the very institution of democracy itself, something we will all be speaking about from different perspectives as we go. My two questions are these. One, is there such a thing as too much democracy? And two, is there ever a wrong time for democracy? These are provocative questions indeed, and I ask them with some hesitation because I'm loath to present myself right off the bat as being anti-democratic in outlook or in values. As a scholar of Nazism and of genocide, I can assuredly declare that democracy by a wide margin is the preferable alternative to other political philosophies, but a cold, hard look at the Weimar Republic and Hitler's assumption of power might suggest, in fact, that where democracy is concerned, perhaps there can be too much of a good thing. And further, that its success, democracy's success and legitimacy is very much dependent on or defined by external conditions. That is, as an idea and practice, democracy may not contain within itself all the attributes needed for its own success and endurance. No. Confronted by the unprecedented suffering wrought by the Holocaust, we are moved, of course, to look for explanations. How could it have come to that? It's a long, complex answer, but the starting point is with Hitler and the Nazi Party. Hitler articulated a worldview in which Jews had no place, and the Nazi Party and its organizations put these ideas into practice. So how did Hitler and the Nazi Party come to power? Germany was, after all, a country of philosophers, composers, Nobel Prize winners, and writers. Explaining the Nazi seizure of power includes a combination of long-term conditions and short-term crises. And so, on the deeper history of Germany's political culture, I can say the following. Germany came very late to statehood. It was 1871 before it was unified. It was ruled by an emperor who was born, not elected. He appointed a chancellor, who in turn appointed a cabinet. They headed government. There was a nationally elected parliament, but it had no say in who really was making the important decisions. Germany's first chancellor was Otto von Bismarck. He was ruthless, cunning, uncompromising as a leader, and he trampled civil liberties of groups like Catholics and socialists in order to shore up control and authority in the new German state. He did things like limiting the freedom of press and assembly, dissolving political parties, staging mass arrests for suspected dissidents. And this was done in full view of, indeed with, the support of so-called liberals whose highest goal was national unity. And I tell you about these things in order to illustrate that Germany did not have a long-standing tradition of stable parliamentary democracy, and that its tradition of human rights and civic freedoms was tenuous and fragile long before the Nazis came onto the scene. Then, Germany's political identity completely changed with the First World War. It was in the context of the devastating losses of the Great War, military mutiny, socialist revolution, and the emperor's abdication that power was handed to the, at the time, largest political party, the Social Democratic Party, to form a republic, which they did at the city of Weimar, and that's where it gets its name, the Weimar Republic. The Weimar Republic's constitution was far more liberal and democratic than anything in Germany's history. Now, the Chancellor and cabinet answered to the parliament, called the Reichstag. This was elected by universal suffrage. Women also voted. The people also elected a president. Further, the Constitution provided for proportional representation. If a party won 1% of the popular vote, it had claim to 1% of the parliamentary seats. That is, there was no minimum threshold for representation in the Reichstag. On first glance, this appears ultra-democratic, progressive, liberal, in that every voice had a platform and every vote counted. In practice, however, the system had great potential for chaos and division, and this is what I mean about there possibly having been too much democracy. With the founding of the Republic, political parties proliferated, many of whom had very little political experience and who catered to and advocated for their own particular constituency's set of interests. This had the overall effect of magnifying divisions within German society. None of these parties could win or sustain a clear majority on their own in the Reichstag, and so governments formed on the basis of coalitions, which understandably were contentious and short-lived. The coalitions themselves made for strange bedfellows, with pro-Republican parties often requiring the support of conservatives whose rejection of the Republic was open and unapologetic. The situation resulted in continuing cycles of elections, the formation of governments, coalition collapses, and then new elections. Between 1919 and 1928, there were 15 separate cabinets. The longest lived among them was 18 months, the shortest less than 3. In the early 1930s, in attempts to avoid parliamentary stalemate, the president invoked his rule to rule by decree. This was a mechanism that was built into the Weimar Constitution. In times of emergency, the president could suspend the Reichstag and simply dictate legislation. So even before Hitler came to power, the Republic was, in a sense, functioning against its own ideals, undemocratically. If these conditions weren't troublesome enough, the Republic was beset by several attempted revolutions and coups. There were communist coups in Berlin and Bavaria, which followed very closely on the heels of the First World War and the foundation of the Republic in 1920. The Kapp Putsch, which is the German word for coup, the Kapp Putsch attempted to reestablish the empire. And then in 1923, a little-known upstart from the far-right German Workers' Party, Adolf Hitler, staged a coup in Munich. This one was called the Beer Hall Putsch. And for this, he served only 18 months in prison. The series of coups contributed to the sense that war, this time civil war, could re-erupt at any moment. Moreover, they did little to foster confidence in the new political system. More importantly, though, the laughable punishments handed down after the Beer Hall Putsch were symptomatic of a far-reaching problem in the Weimar Republic, which was that Germany's basic institutional culture did not undergo revolution along with the switch to a republican democracy. The army remained more or less a state within a state, picking and choosing when it did and did not support the security of the republic. Judges, teachers, and civil service bureaucrats from the imperial period remained in their jobs and continued to act as though the Second Empire had never ended. School curriculum remained unchanged. Government functionaries openly derided the Republic. In courts, judges, far from being neutral arbiters of the law, consistently favored the right over the left. It was, as has been said by many historians, a republic without Republicans. Then there was a string of economic and social crises. In 1923, there was a hyperinflation crisis of unprecedented proportions. Money was not worth the paper that it was printed on. Suddenly, only tangible goods had real worth, and so the hyperinflation crisis ushered in a sharp increase in crime. The fact that the Weimar government had contributed to the crisis and then proven itself unable to fix it, or rather fix it quickly enough, only further embittered citizens against the Republic. Then the 1929 stock market crash hit, affecting Germany severely. The unemployment rate rose to 40%. But these were much more than simply economic crises. They brought with them terrible psychological damage. People's savings were wiped out literally overnight. Formerly well-to-do people found themselves penniless, miserable. There was widespread hunger, homelessness, crime, and moral degeneration. Hopes for a better future faded. Many Germans came to believe the current government could not save them, that indeed democracy itself might be part of the problem. As coalition after coalition collapsed over disagreements on economic policy, people lost faith in the principle of the parliamentary system. By the end of 1930, the Nazis and the communists, the far right and the far left, had become two of the largest parties in the Reichstag. Now, as we know, Germany's problems were complex: social, economic, political, military. There were multiple economic crises, a chaotic government structure, conflicting political messages, a dismal situation vis-a-vis international affairs, particularly after World War I. The Nazis promised to free a divided and humiliated Germany of all its ills. What were Germany's ills? Communism, modernism, the worst of capitalism, liberalism. And the Nazis said all of these things could be attributed to, blamed on, the Marxists and the Jews. The Nazis promised a radical new beginning. A powerful Führer would rule the Third Reich. All enemies of the state would be driven out. The Jews, who were allegedly responsible for Germany's woes, would be excluded from the national community of the people. There would be no more parties, no more governmental squabbling. The will of the people would be embodied in Hitler himself. In the end, the Nazis were more successful at taking advantage of political instability and exploiting the weaknesses of the Weimar Constitution. That is, Hitler did not invent Weimar's problems or its weaknesses, he exploited them to his advantage. To be sure, it was those early years of the Depression that catapulted Nazism onto the national political stage. In 1928, the Nazis had won 2.6% of the vote. In September 1930, their share of the vote jumped to 18.3%. The major breakthrough came in July 1932, when the party won 37.4% of the vote. And I think we should give ourselves a moment to let that figure sink in. 37%. It's significant, but it's not a majority. 2/3 of the German electorate still rejected the Nazis. At the same time, over 50% of the vote went to parties of the extreme right and left. So Germany in the 1930s, it was polarized, it was extreme, it was highly politicized, yes, but it was not rabidly Nazi. But from March 1930 on, the Chancellor, with the President's approval, began ruling by decree in attempts to break free of the cycle of coalition collapse while still steering a middle course between the extremes of right and left. Although this was constitutional, this was still working within the laws established in the Republic, it signaled the true end of democracy in Germany. The Chancellor was now more or less running a dictatorship, a constitutionally legal dictatorship, but a dictatorship nonetheless, and doing this under presidential authority. This would leave an impression on the public imagination, on public attitudes. When Hitler was appointed Chancellor just a few short years later, the people were already accustomed to a government ruling by decree. In the meantime, the continued atmosphere of mass unemployment, strikes, and civil unrest suggested that Germany might be headed toward a Bolshevik-style revolution. And the communists' one uncompromising enemy was Hitler and the Nazis. People felt that it was no longer a question of whether Germany would be ruled by either democratic or extremist forces. Rather, it seemed the choice would only be between the extremes on left and right. In this atmosphere, top advisors to the president suggested that he appoint Adolf Hitler to the post of Chancellor. Although everyone knew that Hitler was extreme, they thought that the Nazi Party was the only one that could form a workable coalition in Parliament. They wanted to exploit this 37% vote. But they thought that by surrounding him within this coalition, giving him only 2 cabinet seats, would be enough to contain him from becoming too powerful or causing too much damage. And on the 30th of January 1933, Hitler was indeed appointed Chancellor. A fortuitous case of arson of the Reichstag building gave Hitler the pretext to declare a state of emergency and invoke powers to suspend civil rights and freedoms. He then orchestrated the passage of another law, this one was called the Enabling Act, which handed him dictatorial powers for 4 years. So whereas before the Chancellor was ruling by decree with the President's approval, this removed the obligation for that approval. And the rest, as they say, is history. I've told only the very bare bones of the story, but I hope that what we remember about this is that Hitler worked within the Weimar Constitution to achieve power. His assumption of the office of Chancellor, his passing of the emergency decrees and the Enabling Act to consolidate his position, these were all measures that were contained in the Constitution. He did not destroy Weimar from the outside. He did not seize government through a coup d'etat. Rather, he exploited the weaknesses of the existing system, got a little bit lucky, and collapsed it from the inside. And this is what I meant about there perhaps being a wrong time for democracy. In a country with shallow experience of democratic institutions, which was then beset by a series of political, social, and economic crises, any one of which would have challenged even the most solid of democratic countries, perhaps we see evidence that the temporal context in which democracy exists may have far-reaching effects on its viability. The very things that make democracy great, its allowance for plurality, its tolerance of dissent and change, in times of repeated crisis, these may in fact undermine its legitimacy in the public eye. Thank you.
Thank you, Valerie. That is a great historical entree to our next topic. I'm going to ask David Diesenhaus to come forward and discuss the use of the law and the role of lawyers in advancing the Nazi agenda and ultimately the Holocaust.
Right, so I should say thank you very much for having me. And I'll start with an apology, and that is that I have to leave immediately after our session is over, so I can't stay for the reception. So if you see me running away at the end, it's because I have to get somewhere else. It's not because I'm frightened of you. Maybe I should be frightened of you, but after you've heard what I'm going to say. And I might need to run away in particular from Valerie, because I want to start off by disagreeing to some extent with some of the things that she said. So in the book that was mentioned earlier on Weimar legal theory, made a fairly close study of the Weimar Constitution in the political context of Weimar. And what intrigued me most about my study was how close Weimar Germany came to succeeding, despite the odds that were stacked against it, as Valerie so graphically described. When one gets to the early 1930s and the chancellorships of people like von Papen, these chancellors were not trying to steer a middle course, as I understand it, between the communists and the Nazis. They were trying to steer as far right a course as possible without tumbling over into Nazi ideology. What's more, not only did they not care about democracy, they did not care very much about legality. One of the major events prior to the Nazi seizure of power in 1932 is something called the Preußenschlag, where the federal government took over the machinery of Prussia, which was not only by far the largest land or state, but also the last bastion of social democracy in Germany, a quite different kind of ideology from communism. I believe that this Preußenschlag, translated into English as the coup against Prussia, was completely illegal, and the fact that the court that was charged with determining the legality of the Preußenschlag found that it was legal does not, in my view, in any way detract from the judgment that it was completely illegal. And German legal historians regard this executive seizure of power, taking power away from the legislature, as a very important step towards what one sees in a much more dramatic fashion during the Nazi years. And to say that Hitler came to power within the constraints of the Weimar Constitution, came to power democratically, is, I think, to vastly understate the kinds of nuanced judgments that are involved in making that claim, because I think one can argue quite convincingly that not only Hitler, but the presidential cabinets that preceded him were acting outside of the confines of the Nazi Constitution. Now, this book on Weimar legal theory is a book about a fascist legal thinker, Carl Schmitt, and then two highly assimilated Jewish thinkers, Hans Kelsen and Hermann Heller. Together, these three were perhaps the leading public lawyers of Weimar. And the book is dedicated to a third highly assimilated European Jewish lawyer. That is my grandfather, Ludwig Deisenhaus, a prominent Warsaw attorney murdered in a reprisal in the early days of the Nazi occupation of Germany. Strangely, I know less about him than I do about the three lawyers who feature in my book on Weimar legal theory, in part because my father was almost totally incapable of talking about the war years. And I wanted, however, at a time when we are remembering the Holocaust, to remember him publicly to an audience of lawyers and others who I think I can safely assume share my grandfather's liberal humanitarian ideals. I engaged in the research for that book in order to try to understand better the kinds of events that Valerie so vividly described to us. That is, how a society, which in many ways was the birthplace of Enlightenment ideals, could give rise to Nazi Germany. In particular, how could this happen in a society which had done so much to establish in the modern consciousness the idea of the Rechtsstaat, the rule of law state? And now, I'm afraid, a further bit of biography. As you can tell from my accent, I'm a South African. I grew up in South Africa, in apartheid South Africa, and I found fascinating as a law student in apartheid South Africa that in a context where there was no Bill of Rights and the racist government had an iron grip on Parliament and the laws that it had enacted, that law could still be used to resist law. As long as the government was committed to ruling through law, legality or the rule of law disciplined the content of the law. The only way for the government to escape this discipline was either to rule extra-legally by placing what officials did outside the reach of the law, or to declare in its law that a group was less than equal in the eyes of the law, and thus beyond the equal protection of the law. So either extra legality or declaring that a group is beyond the equal protection of the law. And the conclusion I came to in my earlier work on South Africa was that law's form constrains content. When it ceases to constrain content, law disappears. And this is because law, as I understand it, is implicitly or explicitly committed to formal equality, to the dignity of all those who are subject to it. And I think that one will find exactly the same conclusions in a study of either late Weimar or of the Nazi period. So I've already dealt, as a kind of polemical start to my talk, with what I regard as the myth of the Nazi legal seizure of power. I believe it was an illegal seizure of power. And what we see in the early years of the Nazi period is the victory of what a very distinguished German Jewish lawyer, Ernst Fraenkel, called the prerogative state. Fraenkel, in a book published in the early 1940s, The Dual State, explained that there were two states in Germany. There was the normative state, which was the survival of the Weimar legal order into the Nazi order, and then there was a prerogative state, which was the rule of the Nazi executive, which could at any point in time displace the normative state. And this is the extra legal bit that I talked about earlier, ruling outside of the law. But substantively, within the normative state, Jews were declared ever more in both public and private law to be less than equal. And the way for this was prepared by a quite self-conscious rebellion by Nazi legal scholars against what they understood to be formalism in legal thought. because they saw clearly that law's commitment to formal categories, especially the category of abstract legal personality, got in the way of the kind of political order that the Nazis wanted to create. This commitment to formalism precluded making a kind of substantive distinction in the law, which one had to make in order to put in place an order based on the Nazi idea of the people or folk. But I think that also that if one studies the Nazi period closely and the way that law was used, what one will find is that this kind of substantive use of the law for evil purposes can only be pushed so far. There comes a point where evil has to take place outside of the law. And this idea, I think, is wonderfully conveyed in an article in the University of Toronto Law Journal written by a former student of mine, Kristen Rundle, called The Impossibility of an Exterminatory Morality. And the idea in this article, which I think is very cogently argued, is that the Holocaust could not have been legally authorized. The Holocaust had to take place outside of the law. The way for the Holocaust could be prepared by laws that discriminated against Jews, but when it came to the extermination of part of the German population, that was not something that could be legally authorized, as the Nazis themselves recognized, by ensuring that when the Holocaust happened, there was no legal authorization for it. It took place in some extra legal space. And I take this to support a rather interesting conclusion about law, and that is that law is inherently committed to human dignity, so that if the most extreme violations against human dignity have to take place outside of the law. Now, just one word about the role of lawyers. The first president of West Germany said after the war, echoing a remark that was made by Valerie, that the problem with Weimar was not in the Constitution, but that there were not enough Democrats. And there were also not enough democratic lawyers. Law did provide a resource in Nazi Germany, as it did in apartheid South Africa, which could be exploited by lawyers who were minded to resist the oppression that they saw around them. That lawyers did not exploit that kind of resource was, I think, not the fault of the Weimar Constitution or the fault of the Weimar legal order, but a failing in character among Weimar-era lawyers. And I think one has to take into account that when we think that perhaps lawyers should take on this kind of role, using the law to resist the law, that those lawyers are often not praised in the society where they take on that role. In fact, they're often denigrated and honored only in retrospect. And it's actually very hard, I think, in any society for lawyers to take on this role. So we should not be surprised that in the conditions of Weimar Germany, and more particularly in the conditions of Nazi Germany, that there were not lawyers, or not enough lawyers, who were willing to take on this kind of role. Thank you very much.
The phrase Nazi legal scholars sounds so dissident to me. But thank you for your excellent remarks, David. You've generated in my mind about a dozen questions, but I think we'll go through our panelists and then open it up to everyone to be able to ask questions. So, Oral, let's move forward to the present for a little bit. To what extent has the world not learned from the lessons of the Holocaust?
Well, first, let me thank the Upper Canada Law Society, Brith, and Mark for inviting me, and a very generous introduction. That was 1 minute, 31 seconds. I hope I can recapture that, but I appreciate it. And I'm also very glad to follow Valerie and David, because I think what they've said was profoundly important in providing a context for understanding the present. Now, I produced a paper because my time will be very short here, but perhaps some of those papers might be available. Some may have been printed off, and perhaps It may also be put on some website. They're outside, okay. So the question that you ask, Mark, is a profoundly important one, because there's always a justified fear that we have not learned from history. Learning the lessons of history is crucial. Indeed, we should very much take to heart Kierkegaard's dictum that life must be lived forward, but can only be understood backwards. Yet, as much as we would like to make sure that we learn the lessons of history, it is equally important, as my Harvard colleague Stanley Hoffman has noted, not to learn the wrong lessons. And my concern is that not only have we perhaps not learned on the lessons that we should, but we may have learned some wrong lessons. And so my talk, in fact, is entitled, my address, The Holocaust, Wrong Lessons, and the New Antisemitism. And there is a tremendous emphasis now on Holocaust studies, Holocaust museums. This is all very, very beneficial. But one also wonders if everything that we should has been absorbed and understood, or whether perhaps we have made some mistakes or are making some mistakes. Jews were definitely the victims of the Holocaust, but this most horrific historical crime was certainly not an exclusively Jewish issue. Any perception, consequently, that anti-Semitism, which culminated in the Holocaust, or even was exclusively or necessarily just a primary Jewish issue in the larger context of what happens to democracies, I think it is mistaken. Genocidal anti-Semitism, in fact, is emblematic of an unraveling of social norms of fair behavior, a collapse or loss of vital social capital that binds good societies together. It is not accidental, I would argue, that anti-Semitism has been central to right-wing, left-wing, and theological totalitarianism. Consequently, what has been called the oldest hatred, the hatred of Jews, means that when it comes to anti-Semitism, Jews function as the canary in the mine, an early warning signal of the most dangerous social dysfunction. And this is why what anti-Semitism also means is a threat to everyone's rights and freedoms. And this is why we need to ask certain important questions when dealing with anti-Semitism. Is it possible to engage in a kind of triage where we prioritize what type of anti-Semitism we might fight? And that's, I think, highly problematic. Equally, we should critically examine the assumption that education by itself can solve the problem, that good speech will suffice in defeating bad speech, and that civilized dialogue will necessarily, or at least eventually, enlighten and persuade extremists. The threats of extremism are most consequential to democracies. It is not that democracy is a fragile flower, for it is by historical standards indeed a hardy weed. Nonetheless, democracy involves a continuous struggle whose success depends on consistent engagement, on meaningful citizenship, on the courage to speak out, on challenging pernicious ideas, and yes, on the use of law to defend democratic societies against those who would violently destroy it. There are consequently no guarantees for achieving democracy or for preserving it. And we're witnessing this today. In 1989, there were tectonic shifts which brought about a phenomenal transformation. The Soviet Union imploded, communism collapsed in Eastern Europe. There were historical opportunities. We don't have time to go into all of these things, but we can see a gradual constriction of the democratic space. And this is extremely worrisome. You can lose democracy. You can lose parts of democracy. And if I may mention one of my books, The Extreme Right, Freedom and Security at Risk, this was written a number of years ago, talked about these kinds of dangers. And sadly, this has come about. And we also see what happens quite recently. The hijacking, or what has been labeled as the Arab Spring, where millions of people sought to reclaim their dignity and spoke out fearlessly for their rights. Yet in places like Egypt and Tunisia, Islamist regimes that have nothing but contempt for democracy and rights the ruling elites of these regimes who in fact view democracy as a kind of bus that they are willing to ride until they get to their totalitarian theocratic destination. They have taken over and are eliminating popular gains of the revolution day by day. And it's not surprising that the latest survey on anti-Semitism conducted for the European Jewish Congress shows that anti-Semitic incidents last year increased 30% worldwide. So when we look at these lessons, there seems to be a tremendous amount of complexity. And I would suggest that we have to reduce that complexity as much as we academics love complexity and we want to avoid simplicity because that can lead to distortion and we don't want decontextualization. So I suggest a kind of Occam's razor approach where we emphasize succinctness in logic and problem solving. We should avoid what the British call being too clever by half. We must not mistake sophistry for sophistication or confuse demonization with discussion. And I think this is one of the key elements in approaching what we look at in terms of the type of anti-Semitism that exists. And sadly, it's on the far left, on the far right, and on in theological extremist movements. We often are well attuned to anti-Semitism, threats to democracy from the far right because historically fascist and Nazi movements have been thoroughly discredited. The problem is we don't always have the same kind of sensitive antennae for the extreme left. And it goes back all the way to Karl Marx. Regardless of how much his disciples have tried to whitewash what Karl Marx said or did or wished, Karl Marx, starting with his work on, it was called On the Jewish Question, manifested a kind of profound anti-Semitism which portrayed the Jews as a yardstick of evil, where there was a repetition of the worst kind of anti-Semitic tropes which became classics of, as Bernard Lewis said, classics of anti-Semite propaganda. And this has permeated the far left. It was amplified by Vladimir Lenin's prescriptions for revolution, which stipulated that ends justify any means. And this is something Marxism-Leninism has provided a kind of pathway where you see this kind of melding and alliance of the extreme left and of theological extremism. It is a pathway for a cynical, tactical alliance between the hard left and the Islamists. And when we come to the latter, the anti-Semitism of, not of Islam, but, and I want to emphasize that, but of Islamism, you see this manifested by people like President Morsi of Egypt, who labeled Jews as pigs and monkeys, the worst insult you can think of. Ahmadinejad, who's a Holocaust denier, calls for the elimination of Israel. Recep Erdogan, the Islamist leader of Turkey, where freedoms are constrained more and more every day, where there are vast numbers of journalists in jail. He called Zionism a crime against humanity. So when we talk about anti-Semitism, and I just have a few minutes, I think, what do we mean by that? And we do have some really good working definitions of anti-Semitism. So we don't just use that, should never use it lightly, but there are rigorous ways in which to define what anti-Semitism is. And so, for example, the European Monitoring Center on Racism and Xenophobia, now called the Fundamental Rights Agency, provides us with a number of standard of criteria for judging what anti-Semitism is. One of them is denying the Jewish people their right to self-determination. That is, by claiming that the existence of the State of Israel is a racist endeavor. The use of symbols and images associated with classic anti-Semitism is another one. Accusing Jews as a people of being responsible for real or imagined wrongdoings committed by a single Jewish person or a group, or even for acts committed by non-Jews. Drawing comparisons of contemporary Israeli policy to that of the Nazis. Applying double standards by requiring of Israel behavior not expected or demanded of any other democratic state. We also had here in Canada an agreement, the Ottawa Protocol, 2010, where David Matas and I participated, and there were parliamentarians from dozens of countries, representatives from every major party in Canada, so it was a remarkable consensus. And this is part of that document. It said, let it be clear, criticism of Israel is not anti-Semitic, and saying so is wrong. But singling Israel out for selected condemnation and opprobrium, let alone denying its right to exist or seeking its destruction, is discriminatory and hateful, and not saying so is dishonest. And I think we should remember that. The great Soviet dissident and major Jewish leader, Nathan Sharansky, formulated a 3D test for anti-Semitism. And the first one is demonization. Second is the test of double standards. And the third is that of delegitimization. And years ago, when I was doing research for one of our books, I interviewed Adam Michnik. It was after the fall of communism. I was in Poland. Democracy was beginning to flourish. Adam Michnik is also the editor of the largest Polish newspaper. And a survey had just come out. There used to be 3.5 million Jews in Poland. There were only about 8,000 left. The survey that was taken indicated that 36% of the population in 1994, 36% of the population believed that Jews had too much power in Poland. This was the remnant of a once glorious community, 8,000 elderly people who could barely make ends meet, and there was that kind of perception. And what Michnik said was that you don't need Jews for anti-Semitism, that there was this kind of concept of the Jew writ large. That is, Jews, he explained, were viewed as representing modernity and change, and the new anti-Semitism reflected popular fear or rejection of such modernity. And this is one of the problems with anti-Semitism, that it transmogrifies. It takes on new forms, and when we look at the 21st century, we have to understand that it is not just the most blatant form of anti-Semitism and the threat to democracy, but the subtle forms are equally important. And there are four kinds of anti-Semitism in the 21st century I wanted to address. And do I have a couple of minutes? Sure. One is the designation of Israel as an apartheid state. Irving Kotler labeled this rightly as one of the new forms of anti-Semitism. It is a clever and profoundly Orwellian exercise where the right of free speech is stood on its head. The first test run for this was at the University of Toronto in 2005 with the introduction of Israeli Apartheid Week. Now, if you look at this closely, if you look at the website, you will see that this is part of lawfare. This is not just some accidental development on campus by a group of students who decided that they were upset over some particular set of issues. It is a very well-formulated program that draws on the old Soviet resolution, Zionism is Racism, which was passed in the UN General Assembly in 1975. It was revoked in 1991, and it was reintroduced in another form at the first Durban Conference in 2001. And when you look at this, this is indeed part of lawfare, because apartheid is not an ordinary word. The Rome Statute, which governs the International Criminal Court, lists this as the crime of apartheid as one of the crimes against humanity. The crime of apartheid means inhumane acts that are racial. Paragraph 1 refers to murder, extermination, enslavement. To label Israel a multi-racial democracy where Arabs and Druze sit in parliament and on the highest courts, and where people of color have important positions in government, business, and academia, as an apartheid state is more than a sordid absurdity. It is to designate an ally of Canada, a country with whose government funded educational institutions in many Canadian universities, including the University of Toronto. There are very strong links. This is demonization. It is criminalization of Israel. But very importantly, it instantly criminalizes faculty, students, volunteers, Jewish and non-Jewish in any way support Israel's legitimacy by portraying them as accessories to a vile international crime. And there's a derivative of Israeli Apartheid Week, which has become a year-long event. It has spread to over 100 institutions, and that is the boycott, divestment, sanction movement. Despite Canadian laws, and we've had student groups pass it at York University, University of Toronto, Mississauga. It is a kind of 21st century version of McCarthyism, which doesn't commence a discussion, it shuts it down. It criminalizes, demonizes, dehumanizes, and it ostracizes. A second one is a new term. Again, the twisting of language, pinkwashing, an article that appeared in the New York Times. And that has taken on a life of its own. And what it basically says is that Israel's widely admired record on pro-gay rights, where hundreds of Palestinian Arabs have fled to Israel in the face of death and torture in Hamas-controlled Gaza or PA-controlled West Bank, is nothing more than a cynical diversion designed to divert the international media from the real plight of Palestinian Arabs. And it is a kind of old anti-Semitism repackaged, which basically is saying no matter what the Jews do, even if it looks good, there's some sinister purpose to it. It's the same kind of thing that when Israel sent very quick medical aid to Haiti, a good deal of the Arab press said, well, there is a reason why the Israeli Jews are in Haiti. They're there to harvest the organs of the victims and sell them on the market. That is what Jews do. This is what pinkwashing is doing. The third is the hijacking of rights and language. And here I will speak just very briefly in terms of personal experience. I was appointed through our Governing Council Act as Chair of Rights and Democracy for 3 years. I completed that. And this was supposedly a major human rights organization funded by the taxpayers at $13 million a year. The job was, the full title was the International Center for Human Rights and Democratic Development, known commonly as Rights and Democracy. It was meant to promote democracy, protect human rights. Well, I found that we didn't protect democracy or really care that much about human rights in much of the world, not huge swaths of parts of the world. But in fact, there was a great deal of activity in terms of the Middle East. And it was hidden. It was hidden from the board of directors using taxpayer money. We found out, and David Matus and I, David served on the board as well, we found out that, for example, Rights and Democracy, contrary to government policy, and we were responsible to Parliament, had helped organize the notorious Durban II Review Conference Hate Fest. And then the president at that time of Rights and Democracy, the full-time employee, Remy Beauregard, not only consistently denied this before the board of directors, but went and testified before Parliament and perjured himself. Purged himself. He lied like a trooper and said, no, we had nothing to do with it. We subsequently found documents which provided incontrovertible proof that Rights and Democracy had participated in the organizing of Durban II. We also found that they funded groups which underpinned a good deal of the Goldstone report, which leveled unfounded accusations of major Israeli crimes during the Chancellor operation. Justice Goldstone later himself disowned the central parts of his report when he became aware of the facts. And this is why, despite trying to transform that organization, David Matus and I had to recommend to the government that it should be shut down, and it was. The last part, and I don't know if I have time for this, is another feature of the new anti-Semitism, and that is the use of Jews as a Praetorian Guard. To look at Jews who will be at the forefront of demonizing, delegitimizing Israel, and then to say, well, Jews have done this, we can do it, it's fine. And how often have you heard some of the harshest critics, and we're not talking about legitimate criticism of Israel, or most of the criticism of Israel, but those who deny the very right of Israel to exist, who basically label Israel as a Nazi state. How often do you hear these people start by saying, as a Jew, I want to say this. And my inclination would be to say, at that point, if you're in the audience, excuse me, but you have no facts, you have no argument, because otherwise, why do you need to tell me you're a Jew? What does it have to do with it? Either you have the information, you can persuade, but don't use that label. Don't employ a fig leaf. And this is something that has become so common. The latest example was Amira Haas writing an article in Haaretz where she justifies stone throwing as the birthright and duty of everyone subject to foreign rule. And she wrote this piece, it appeared in Haaretz, one day after the conviction of a Palestinian Arab for using stones to hit a car in which Asher Palmer and his infant child, Jonathan, were killed because it resulted in a crash. It was 1 month after 2-year-old Adele Bitton in Israel was critically injured, she's sitting in a coma, by a stone-throwing attack. And there is this kind of use of Jews as camouflage and license, and this is part of the new anti-Semitism. So let me conclude. It is essential to understand the Holocaust as something that was driven to a significant degree by a collapse of democracy, but by anti-Semitism, which contributed also, it was part of that collapse of democracy or the inability to create democratic societies. It is vital to appreciate that anti-Semitism, as I noted, a remarkable ability to transmogrify. We have to look at the subtle as well as the blatant forms. And those who have viewed and would view anti-Semitism as exclusively a Jewish problem historically have made a fatal mistake. Among the lessons we need to draw from the Holocaust is that when it comes to anti-Semitism, it should be clearly understood that it is not viable or wise to do a triage. Addressing anti-Semitism requires a version of the broken windows theory. That is, no form of anti-Semitism anywhere can ever be acceptable, and every type needs to be fought at all times, whether in the public parks, in the political forums, or on university campuses. Thank you.
That was wonderful. Thank you, Aurel. I'm going to turn, last but not least, to Lorraine and ask her to what extent has Canada and the international community responded to the Holocaust and genocide more generally, particularly in the constitutional field. That was wonderful. That's why I let you go 10 minutes.
It's sometimes very difficult to come last in such a group of esteemed experts. But in fact, I think that the comments that I want to make this afternoon only make sense in the aftermath of the wonderful depictions of the social, political, legal, and historical background of the fall of the Weimar Republic, the rise of the Nazis, and the perversions, pathologies, and atrocities of the Nazi period. Today is a day when we think particularly of the terrible atrocities that were visited upon the Jews during the Second World War, the personal suffering, dispossession, loss of family, home, identity, freedom, democratic engagement, citizenship, and even life. Many of us have very personal connections to that tragedy, and many of us have intellectual and professional interest in understanding what happened and understanding how we now respond. The story is so complex, and there are so many different ways of understanding what went wrong in terms of the Nazi seizure of power. We even have disagreement on the panel as to whether the Nazi seizure was within or outside the existing Weimar Constitution. Of course, to begin to speak about what the response has been or what it should be is a great challenge. So I want to step back from a lot of the detail that we've been looking at and encourage you to think about what was the conceptual core pathology of the Nazi regime. It oppressed political dissidents, liberals. It oppressed racial and religious minorities, sexual minorities, women. The civilian population was oppressed, defeated, spied upon. The prisoners of war were treated very, very badly. The civilian populations that came under the power of the Nazis, they were enslaved. Early in the Nazi regime, there was widespread euthanasia in which the medical profession enthusiastically participated. The whole envelope of general atrocities, of course, reached their extreme in the genocidal racism against the Jews. But what I want to point out is that the idea of racial supremacy and the idea of the imperative of racial world domination was an aspiration of Hitler that can be understood to have brought about much of this pathology. And of course, we know that Hitler was not resisted sufficiently when it might have been effective to resist him, that once he was in power, any resistance was futile and, of course, very, very dangerous, and many people suffered for trying to fight against the regime or protect people who were the regime's enemies. It took a world war to end Hitler's power, and the fact that it did take a world war is a clue to how we actually think about preventing such developments in the future. As a constitutional lawyer, it seems to me that one of the most monumental and successful responses to the Holocaust and to the general pathologies of the Nazi regime has been the development of what I call the post-Second World model of constitutionalism. Now, it's not just an idea of constitutionalism at the nation-state level. It goes beyond the nation-state. It operates within the nation-state in terms of human rights statutes, for example, common law protection of rights. But it also extends beyond the nation-state to regional rights protecting instruments and international rights protecting instruments. It is crystallized most clearly, though, at the constitutional level, and that's why I call it the post-war model of constitutionalism, in that it crystallized in nation-states that had been defeated in the Second World War. It followed the path of revolution and civil war in many countries. It developed in the end of colonialism in other countries, and we see it most clearly in the aftermath of the regime change instituted by the fall of apartheid and communism. And to a certain extent, we see, not in the past, but in the living moment, the same process going on internally in the various presentations of the Arab Spring. So what we have in the post-war model is a remedial model that addresses all sorts of constitutional pathology, including the kind of pathologies that led to the end of the Weimar Republic, and that the pathologies that were visited upon so many innocent victims in the Second World War. Another way of referring to this post-war constitutional model is to take these historical examples that I've mentioned of regime failure and see their new commitments to governance, transparency, justice, and human rights as the dawning of an age of rights, It is unthinkable now that a new nation would be created without a strong Bill of Rights, and we see in the examples of many of these new constitutions that the Bill of Rights comes first in the new constitutional order. And so as we see the pathology of the Nazi system as a system where no one had rights, there was no right to have rights, we see in this new construct of constitutionalism at the very core the idea that every exercise of public power must both respect and protect equal and inherent human dignity. Now, I've referred to regime change of dramatic scope, but we also see evolutionary transition into this post-war model of rights-based democratic and constitutional ordering in the examples of Canada and Israel. And many of you may know that the new fairly recent Israeli rights-protecting instruments of constitutional status were modeled on our Charter of Rights and Freedoms. But the most clear, formal, theoretical model of this new construct of constitutionalism, which protects rights at the core of the whole enterprise of governance, in repudiation of the Nazis' denial of the whole idea of rights. We see it in the German Basic Law of 1949. Now, of course, there are many, many good reasons, once one reflects, to think that it would be post-Nazi Germany that would be most sensitive to the construction of a rights-protecting regime. But we also have, in this historical example, the creation of a new constitutional order from the ashes of destruction of the Nazis. There was no need to compromise. Anyone who would oppose a very, very strongly committed protection of human rights in the new German Republic would simply have no standing. The whole remedial enterprise was to repudiate the wholesale denial of rights to everyone. And so you see in this fully developed model, because it's a civil law model, so it frames the law in a way that common law systems tend not to. We see a protection of many, many rights, but we also see the idea that all rights are based on the protection of the equal and inherent human dignity of every person. We see that the limitation on rights, which we study so much in the Oakes test and the proportionality analysis of the Supreme Court, is tied in the German Constitution's text to the idea that limits on rights cannot deny the essence of the rights. Limitation is not denial of rights. Limitation of the rights in certain instances is to protect the whole project of rights protection. The constitutional state of modern Germany is democratic. It is socially committed, so the terrible economic disruption that led people to want a messianic strong leader would never occur again. It is a federal state to disperse power and to prevent the usurpation of the powers of the Prussian state that David Deisenhouse referred to. It is a political party state, but the type of political parties can never be the type of political parties that were so pathological in the Nazi period, the pre-Nazi period, and then the Nazi Party itself during the Nazi period. It's a political party state where the parties must be internally democratic and where they can be disqualified if they are anti-democratic and anti-rights. It is a rule of law state, but in the deepest sense that David Deisenhouse referred to. It is a separation of powers state, which means that the executive cannot gobble up the power of the legislatures and particularly of the judiciary. The Nazis were famous, of course, for undermining the operation of the ordinary courts and creating other courts which should never have been called courts, which denied any of the features of adjudication that we respect and hope to perpetuate. The German constitutional state is committed to peace. It has strict but achievable modes of constitutional amendment, but it also has basic principles set out, many of them that I've just listed, which are beyond constitutional amendment. This is what they refer to as an eternal constitution. The pathologies that the Nazis introduced into the idea and practice of government cannot happen under this new constitution, even by constitutional amendment. And of course, it was through a constitutional amendment that was far too easy in the Weimar Republic that many of the powers of the Nazis were assembled. It is a defense of democracy. So the idea of democracy has been transformed because the kind of democracy, this formal everyone votes democracy, and wild political parties, some of which were blatantly and openly anti-Semitic and anti-democratic in the Weimar period, this is not permitted. The state, the government, the laws, the courts are able to protect democracy from its enemies, and those who seek to deny the Holocaust or to spread hatred or to deny the project of rights protection or democracy can be labeled as abusing their rights and losing some of the enjoyment of rights for that reason. This is very, very seldom done, but militant democracy is built in the constitutional order of Germany because democracy can self-destruct. And worse still, it can be destroyed by its enemies. Now, the interesting features of the German Constitution have been emulated in other systems, not so much in the text, but it has become a model that has informed the interpretation of many other constitutional systems. And the Canadian system has benefited enormously, if indirectly, by the great learning and sophistication of the judgments of the Constitutional Court of Germany, and also from the insights and the theory that have been brought to bear on studying comparative constitutional law. I want to leave you just with a few quotes from the Canadian system. I think that it's very important for us to be very proud of the Charter, to celebrate its successes, and to encourage our judiciary and our politicians to support the Charter and to continue to develop it. It is a wonderful foundation for rights protection. It is not a complete Bill of Rights. Many compromises were made, but we have been able to present to the world a new model. The Charter is considered to be, in its expression of many of the rights and of the narrow principle limitation clause, to be not only admired, but to be an actual model for the development of new constitutions, including Israel's. But I want to mention, just share with you a quote from one of the early same-sex equality cases in the Supreme Court of Canada, where Justice Corey spoke about democracy and equality. And he said this: "It is easy to say that everyone who is just like us is entitled to equality. Everyone finds it more difficult to say that those who are different from us in some way should have the same equality rights that we enjoy. Yet, so soon as we say that any group is less deserving and unworthy of equal protection and benefit of the law, then all minorities and all of Canadian society are demeaned. If any enumerated, listed in our Section 15 Equality Clause, or analogous group, protected groups added by the courts, is denied the equality provided by Section 15 of the Charter, then the equality of every other minority group is threatened." And what does he conclude from that discussion? That we're all in the same boat, and any weakening of equality lowers the boat, and we're all in risk of sinking. What does he conclude from this? He says, "If equality rights for minorities had been recognized, then all too frequent tragedies of history might have been avoided." Justice Iacobucci and the court and other occasions have stated that the Charter ushers in a new type of democracy, that democracy is much more than majority wins. Democracy is only, it must be tested by the extent to which the majority respects the minority. The protection of equal and inherent human dignity is an enormous step forward for the modern constitutional state. It frames every exercise of public power in modern constitutional states that have this at their core. It creates and directs the way institutions protect our rights. It is an edifice that is much to be admired and to be attended to constantly. And it is, in a sense, an elaboration of a concept from the Jewish tradition of building a fence around the Torah. If we respect, which means leaving people alone to flourish in their individual human dignity, and if we protect human dignity by supporting people so that everyone has the opportunity to flourish as an individual and within their chosen or given community groups and identity, then we have a structure of government that will be stable and will not succumb to its enemies. So it is, to my mind, an idea of governance in which the fence around the Torah, the fence around the key idea of an equal and inherent human dignity, is a fence that we must all participating in constructing and protecting. Thank you.
Okay, we have some time for some questions. We have 2 microphones on the floor. And just as people move to the microphones, maybe I can direct the first question to Valerie, and that is, how successful were the war crimes tribunals post-Nazi Germany in meeting their goals?
Another small question. I wrote a book on the last of the Nuremberg trials. That is, the first Nuremberg trial that was conducted jointly by the Americans, French, British, and Russians. But there were 12 more trials adjudicated by the Americans themselves that few people know about, and I studied the last of these. The trial concerned field marshals and generals, leaders of the German Wehrmacht, the military, for their participation in war crimes and crimes against humanity. And the stated goals of the entire Nuremberg Project, and it really was the Americans who were at the forefront of this from the very beginning, was to try and use these trials not just to assign responsibility and guilt for this unprecedented spasm of criminality, but to use this trial to try and rehabilitate German society, to try and somehow educate German people about what had been conducted in their name, with a view to this somehow provoking this, a forever rejection of the Nazi worldview. And in so doing, also democratize them, steer them back towards that early experiment with democracy after the First World War. And the thing that's really interesting about the Nuremberg Project is, these trials are held and the sentences are handed down. The evidence of criminality is overwhelming and incontrovertible, and yet the interesting part of the story really gets into its own after the judgments come down, and it's what is done with the trial record in those years after that you really see the strength of commitment to these original goals play out. And to make a very long story short, what happens is the judgments get caught up, or I should say the commitment to honor the judgments to those defendants who were found guilty and imprisoned, to essentially keep them in prison. That the responsibility fell first to American administrators who were occupying Germany in the post-war period. This was severely weakened by new Cold War political concerns, because with the new East-West divide, in fact, being drawn right through the heart of Germany, the Americans, as sort of leaders on the West, were very keen to maintain friendly relationships with West Germany and ensure that they would stay as a force on the continent against the ever-increasing encroachment of communism. And the West Germans, realized the political capital they had regained very quickly in this, and said, well, if you want our participation in trying to defend the West against the encroachment of communism, then let our soldiers go. And the soldiers' case was an interesting one because if any trial had the potential to try and rehabilitate German society, and again, these were goals that were repeated over and over again, the substance of how exactly a trial would do this was not something that was well articulated at all. But if ever there was a trial that could perhaps serve these purposes, it was the soldiers' trial that was well placed to do it, because the military as an institution was the one that best represented a cross-section of the German population. Millions and millions of men had served. But in that immediate post-war period, with a very quickly changing political landscape, the West Germans said, well, it's all well and good if you want our support and our cooperation, but we want our soldiers back if you want us to rebuild our military. And the Americans found themselves in an ever weakened position, because on the one hand, they're trying to insist on these punishments as that final articulation of condemnation, that final articulation of justice, which always was symbolic anyway. It's a handful of men representing the criminality of millions. But so on the one hand, they're trying to insist on these punishments. On the other hand, they're faced with a very difficult contemporary political situation where they really felt bound to try and serve the immediate interest first, and very quickly scaled back on those original goals, and in fact gave in to the unrelenting pressure on the part of the West German government and other West German institutions, the churches, for example, and steadily, through clemency programs, parole programs, let all of these convicted criminals go. It wasn't just the soldiers, it ended up extending also to representatives of the SS, doctors who had committed experiments in concentration camps, but it all fell under the umbrella of this now delegitimized political process.
Gary?
Thank you, Mark. Bearing in mind that it's Holocaust Remembrance Day, I'm going to direct this question to all our panelists. Can you hear me all right?
Now we can.
Good. Well, I said, bearing in mind that this is Holocaust Remembrance Day, I'm going to direct this question to all of you. Professor Hebert noted that the Jews were selected as the cause of all Germany's economic ills, and Professor Braun rightly he rightly noted that the Jews are always the canary in the mine shaft. My question is simply this: why the Jews?
I'm glad at this stage in the discussion you've asked a simple question. All right, who would like to take that question?
Excuse me, Mark. Excuse me for interrupting. I realize only too well that it is not a simple question,
Correct.
that there's a complex answer to it. And I've done some reading, but not enough on the topic. And I would like it noted that I have suggested in the past to the organizers of this program, which is a very good one, that we should devote an entire program to that particular topic.
Okay. David?
So, an impossible question, but maybe I'll try to suggest something like a basis for answering it, that in a way comes out of both Oral's talks and both Oral and Lorraine's talks. So Oral talked at one point of a Polish Jewish intellectual and journalist, Adam Michnik. And he said at one point that if you want to understand why the Poles have a problem with Jews, you have to understand that actually their problem with Jews is a problem that they have with democracy. And what did he mean by that? Well, I think if you put your presentation and Lorraine's presentation together, the problem of democracy is how do we live with the other? The person or the group who seems, as this fascist legal thinker Carl Schmitt used to say, existentially different from us. How do we live with the existentially different other? That's a problem of democracy. And the Jews who have often, even when highly assimilated in European societies, seem to others in those societies to be that other, have, I think, come to stand for this general problem which societies face. And that's why we, speaking as a Jew if I may, do sometimes seem to be the kind of perennial enemy. And that is because societies for a long time and for a long time to come, will be struggling with the issue of how do we live with someone who seems to be existentially other in a civilized fashion.
Oral, did you want to comment?
Well, you know, we are academics here, and we are paid to be long-winded and do theses, and so we do studies and we find out that the cause might have been modernity, social disruption, economic factors, incitement, and all these are elements, and I don't want to be disrespectful to a field and discipline that pays my bills, and I live in that environment and lived in it all my life, and I think it's very valuable to look at all the possibilities, because it is essential to try to understand what motivates what has been called all this hatred, and it is still pervasive. And I think all these factors provide partial explanations. But when you examine each one, such as, you know, Jews as a scapegoat, it doesn't really make sufficient sense. None of them really provide an adequate explanation. And even collectively, I'm sorry to say, I'm not convinced that they provide an adequate explanation. At the end of the Second World War, there was apparently a kind of perverse joke, and that was somebody said, you know, the Second World War was caused by the Jews and the bicycles. And somebody said, why the bicycles? And the answer was, why the Jews? I'm not sure we know.
Thank you. Next questioner, please.
Yes, I have a question. For me, what was, and now we have the future, the present and the future. And every Monday and Thursday, we hear that someone in some country, and some high power, will take Israel to the international court, or Israel is Israel is an apartheid state, and the BDS movement has really ballooned since 2005. What happens when countries such as Hungary, which has the Jobbik Party now, and has had a Dr. Sandor Capiro, I believe, Sandor Capiro, who was acquitted for his war crimes not because, you know, there was no witnesses that really saw it, they had lots of documentation, but the country itself is becoming more and more anti-Semitic. What happens, I wonder, in a year or 2 years, 3 years from now, where different countries, because of pressure, because of whatever reason you have, the countries themselves, the judges, whether they're on the far left or on the far right, they become more anti-Semitic. The different countries become more anti-Semitic. What happens to Israel as a country then? Or people, or war criminals? There will be war criminals, or, you know, I mean, people will think they are war criminals, but they're not. But they will be a trial one day, for sure. And I'd like to know what would happen. Thank you.
Who would like to answer that? Oral? All right.
Well, this is obviously a very, very serious question. And it does look sometimes like it must have looked in the 30s, that the world is against the Jews, and that there is just this inexorable, crushing, historical pageant of oppression and disadvantage. But I like to think that the world has really changed, and that the prejudice and ill will that is motivating these political parties and these pressures that are being put on Israel will be exposed for what they are. I mean, we live in a world where there really are institutions and at the supranational level, and countries that are very sensitive to the injustice of all of this, and they do have capacity to put leverage on countries that are following these kind of pathways that you're describing. But we live in an imperfect world, and we have to really struggle for transparency and rationality. And it's a day-to-day battle. And there are obvious things that we can be doing. There are positions we should be encouraging our governments to perform. I think that the Israeli justice system has done such a wonderful job of disciplining a lot of the passions and excesses that might otherwise have taken place that would have exposed Israel to even more of this kind of pressure. And I think it's very important as Jews to be very well educated about the strengths of Israel, but also to be honest about the failings, and so that we put forward in public discourse in our countries and in transnational discourse a rational, thoughtful set of ideas about how Israel should be dealt with in the world.
Earl, you wanted to comment briefly?
Alan Dershowitz very cynically said about the International Court of Justice, it's not international, it's not a court, and it's not about justice. I would like to share Lorraine's optimism, and I think there is hope, but we have to recognize the limitations in these courts of how difficult it is to make the case, and how it's an enormously uphill battle. And how, if you go to International Criminal Court, how problematic that court is, and how biased it has shown itself to be in many respects. So I think it's a difficult struggle, but it has to be conducted. We also have to look at the very pernicious role that the United Nations is playing by referring certain things to these courts with already a predetermination of the results. We have the United Nations Human Rights Council. This is the same council where 152 countries voted to have Libya included, and in the Universal Periodic Review, they praised Libya one country after other under Gaddafi in 2010, when they joined in May 2010, and they praised Gaddafi for his remarkable respect of human rights. This is what we're dealing with internationally. These are the kind of institutions that we have. Over 60% of the issues before the United Nations Human Rights Council involve condemnation of Israel.
It's not only the condemnation I was worried about.
Sorry, I am going to go to the next speaker. Thank you. Just before you ask your question, we're going to ask David Matus to sum up what we've heard and to provide some of his comments. So I'll ask David to kind of come up here as the next question is being asked so that he'll be in a position to do that. So your question, please.
Thank you. I came to the mic because I was concerned of Professor Braun's point that we should make sure that we don't learn the wrong lessons from the Holocaust, and his point that while anti-Semitism clearly affected Jews, it's not just a Jewish issue, and that harassment, discrimination, kinds of oppression affect everybody. And the previous speaker pointed out the problems that exist right now in Hungary. And yes, there's a problem for Jews, but there's clearly a problem for other minority groups, including the Roma. And if we are obviously concerned about the viability of international forms of justice, clearly we have more of a power of influence over domestic tribunals. What are leaders here in Canada who are fighting to defend human rights doing to try and get our national government to take a more realistic view of the needs of refugees here in Canada?
David, you may have come up just in time.
Do you want me to? Sure. Your question is what we're doing to get the government to take a more realistic view of the rights of refugees in Canada. What we, meaning B'nai Brith?
Either B'nai Brith, academics, I mean the population that is here today. People who are obviously concerned, but our concern has to go beyond today's forum back into our lives in the community.
Well, Sure. We have made submissions on the refugee law, immigration law, citizenship law. In fact, we're scheduled to make one next week in Parliament about proposed changes to the citizenship law. So we're doing what we can in terms of parliamentary submissions. The refugee issue is not just a Canadian issue, obviously, it's a global issue, and we've been going to the UN, trying to deal with that. One of the issues we've been very actively involved in is the issue of justice for Jews from Arab countries who are not treated equally with the refugees, the Palestinian refugees, and that's a continuing issue. I think when it comes to dealing with respect for refugee rights, it's a continual struggle, absolutely, and it's a day-to-day struggle. I mean, I'm a refugee lawyer, so I'm dealing with it not just in terms of reform and advocacy, but also in terms of trying to present cases that are effective on a day-to-day basis. And I would say generally, and this is to a certain extent following up from also the question we heard before, there's a question of, what's going to happen and what we can do. What can we do? Well, I guess my general answer is that we can always do better. We have to make an effort to make it better. That what we're talking about is human affairs, which is within our control, and we can't just sit back and wring our hands and say this is terrible. I think that if we want to change, we have to take the initiative to try to make the change we want. And I mean, for my part, I'm doing what I can, and I would ask everybody else to do the same.
Well, I've called upon David before I've introduced David, so, but I always use the resources that are made available to me, so I'll just say, because most of the people in this room know him, he's currently the senior legal counsel to B'nai Brith Canada. He is truly internationally renowned lawyer and a human rights activist. He has done everything in the area of human rights. I don't quite understand where he has the time to do it. He works about 25 hours a day. If he were a member of the bar in Ontario, we'd be investigating him for submitting accounts for more than 24 hours a day, except he doesn't submit accounts for the work and he's not in Ontario. So he's beyond our jurisdiction. So having said that, we did invite David up to comment on what we've heard in the course of the day. And David, before doing it, I never lose the opportunity to take advantage of your expertise. So I do want to ask you one question, and maybe you can weave it into your comments. And that's this, that David Diesenhaus gave us a stark betrayal of the role that lawyers performed in advancing the Nazi agenda. Were there lawyers that resisted the Nazi agenda during World War II?
Yes, okay.
And why don't you come up here?
I will try to answer that. I've been asked to sum up this panel, and I was, of course, asked to sum it up before I'd even heard the panel. So I did try to talk to the panel and read what they've written, and I have prepared some remarks kind of in anticipation of what I thought the panel would say, which is sometimes right. So I'll go through these remarks. The topic of the session is the road from democracy to dictatorship, Holocaust to the present day. That's the way it is in the flyer. So the topic then the panel has been asked to address is not the road from dictatorship to democracy, but the reverse. We were not talking here today about transitions from repressive regimes to rights-based regimes, but rather the degradation from rights-respecting regimes to their opposite. Moreover, we're asked to consider the grim prospect that democracies, including our own, might become, in the present day, dictatorships. The Holocaust, here as elsewhere, is a paradigm example. The Weimar Republic was a democracy, but it turned into its polar opposite, the Third Reich. The degradation from the Weimar Republic to the Third Reich is a warning that we do not inevitably move towards greater freedom and respect for human rights. Sometimes freedom can plant the seeds for its own destruction. How do we prevent that from happening? To answer that, we have to stare in the face the Weimar Republic in the early days of the Third Reich. We have to learn the lessons from that experience and apply it to the present day. The Holocaust seems so remote from our daily lives, so distinctive in the sweep of human history, and we got a sense of that from some of the remarks of Valerie Hébert, that it may be tempting to dismiss it as an anomaly. Yet the Holocaust happened in an advanced industrial state with a full panoply of modern institutions. It grew out of a democratic environment. The Holocaust was the working of ordinary human beings. Failure to take seriously the questions we are asking today is a denial of the human condition. The Holocaust was a crime in which the whole world shared. The engine of destruction of the Jews was ordinary people everywhere. First in Germany, then in countries where Nazi Germany invaded, then the countries from which Jews unsuccessfully sought refuge, including Canada, and the countries which opened their doors to fleeing Nazi mass murderers after the war, seeking impunity. The wrongs continue to this day with the failure to acknowledge the past and release the incriminating archives and to make the laws effective and bring to justice gross violators of human rights. What is to prevent our present-day democracies from being, like the Weimar Republic before us, precursors to devastating massive human rights violations? Before we even consider the specifics of that answer, we have to acknowledge, in light of the Weimar Nazi history, that it can happen. The very fact of democracy is not insulation against its own conflagration. On the contrary, as Weimar has taught us, democracy can become the source of its own destruction. Winston Churchill has said, democracy is the worst form of government, except for all the other forms. One reason that democracy is the best of a bad lot rather than an absolute good is that it can, if not watched, degenerate into one of these other forms. Many have said that internal vigilance is the price of liberty. The Weimar Republic in the early years of Nazi Germany not only reinforce that message, they tell us what we should be vigilant about. Before the Holocaust, its existence was unimaginable. Now that it has happened, we can no longer plead ignorance. Democracy can lead to dictatorship and genocide. Democracy alone is not a self-sustaining bulwark against its own inundation. Freedom is not its own antidote to tyranny. We can use democracy to prevent massive devastation, but we have to use it well. The challenge we face then in promoting respect for human rights is not just advocating reform abroad of repressive regimes. The challenge lies here at home, stifling the growth of the seeds of self-annihilation democracy has embedded in its own soil. One lesson we should have learned from the Holocaust is the need for an effective effort to combat hate speech. The Weimar Republic had hate speech laws, but the Nazis came to power anyways. The lesson that should be learned from the Weimar Republic is not that hate speech prohibitions are doomed to failure. Rather, we should learn first that hate speech laws cannot bear the whole brunt of combating hatred. If hate speech prohibitions are to work at all, they must work in tandem with a coordinated effort for tolerance and against racism undertaken by every sector of society. A second lesson from Weimar is the need to act on hate speech before it is too late. The Weimar Republic shows us that the only time when we have a hope of being effective in combating hate speech is at a time when it is the preserve of a lunatic fringe. Once hate speech becomes mainstream, as anti-Semitism was in the Weimar years, it is too late. A third lesson we must learn from Weimar is the need for substantial sentences for hate crimes. Hate crimes convictions must never be allowed to become just the cost of doing business for extremist groups, as it was during the time of Weimar. A fourth lesson we should have learned from the Weimar Republic is that we cannot rely on the mere existence and functioning of formal institutions of an advanced civilization, neither the law, nor the universities, nor the military to keep us safe. That is something our panel, I believe, has pointed out to us today in spades. These institutions are themselves morally neutral and in the hands of the forces of evil can become accelerators of genocide. While neither legal institutions nor academia have the killing power of the military, the law can provide legitimacy and immunity to mass murder. Academia and the law can give advocacy of genocide platforms. They can provide genocide with respectability. They can grant perpetrators ready excuses for their crimes. academia and the law can be pretty masked, disguising the ugliest crimes known to humanity. In Nazi-ruled countries, human rights violations were perpetrated by means of physical legal structures, and we heard something of this from Professor Diesenhaus. Nazi-ruled countries used the law to pursue the Nazi racist agenda. Germany at the time of the Holocaust was an advanced civilization in a myriad of ways, not least of which was its development of legal scholarship and jurisprudence. It was startling to see the failure of the participants in a fully legal culture, judges as well as the legal profession. And you ask about this. There was one sole exception, Lothar Kreisig. The failure of this profession to oppose Nazi crimes is illegal, and on the contrary, their willingness to participate actively in those crimes. Now, Lothar Kreisig, he was a Brandenburg judge who in July 1940 filed a murder complaint against Philipp Bühler, the head of both Hitler's Chancellery and the Nazi euthanasia program, for the killing of mentally retarded children and adults housed in a local mental hospital. The judge further issued an injunction to local hospitals preventing them from transferring wards of the court without his prior approval. The Nazis, in response, asked Kreisig to abandon his efforts. He refused. He was then ordered retired but suffered no other consequence. He received a state pension from the Third Reich. In light of how little that happened to Lothar Kreisig for resisting so boldly, so late, 1940, in the Third Reich, it's impossible to say that legal institutions went along with Nazi bigotry and the crimes because they had to. Rather, they cooperated because they wanted to. Because of the behavior of the legal profession and the institutions in Nazi-ruled countries, we have to think of the law in a completely different way. The participation of the legal profession in Nazi crimes showed in a way that jurisprudence alone never could the complete divorce between law and morality, between law and the rule of law, between law and respect for human rights standards. The Holocaust showed that an advanced civilization, even an advanced legal culture, is no defense of the worst crimes known to humanity. Legality and barbarity can go hand in hand. So how are we doing today? How well have we learned the lessons about democracy the Holocaust has taught us? The general answer I've heard is not so well. We still do not have effective hate laws. On the contrary, the legal defenses we have against hate speech are being dismantled. The jurisdiction of the Canadian Human Rights Commission and Tribunal over hate speech on the internet is in the process of being repealed through a bill which has passed the House of Commons and is now sitting in the Senate. The Weimar experiences show us that an ineffective hate speech law is arguably worse than no hate speech at all, because ineffective laws can become platforms for hate inciters. The current Canadian Human Rights Act does not have the procedural safeguards in place to prevent its abuse by those who would use it for harassment. The law needs reform, but right now there is no reform in sight, only abolition. The current law is still there in the statute books, yet there is a natural reluctance to use it when it sits on the verge of abolition and is in any case defective. We are effectively left in many provinces only with the criminal code, a law which requires the consent of the Attorney General of the provinces where the incitement took place. That consent is often denied for the most frivolous of reasons. It was impossible to obtain a consent from the Attorney General of Ontario for the prosecution of Ernst Sundell, from the Attorney General of New Brunswick for the prosecution of Malcolm Ross, from the Attorney General of Alberta for the prosecution of Terry Long and the Aryan Nations, or from the Attorney General of Manitoba for, and I'm not kidding about this, for the prosecution of the Manitoba Knights of the Ku Klux Klan. The requirement of consent of the Attorney General serves a gatekeeper function by preventing frivolous, harassing private prosecutions. And it's impossible to expect the courts to sit on judicial review of prosecutorial discretion. Yet something has to be done to prevent the consent of Attorney Generals from being denied arbitrarily. Brith has asked the Attorney General of Canada to work with his provincial counterparts to come up with guidelines for the exercise of this consent discretion. But so far, nothing has happened. How far are we today from the Weimar Republic of pre-Nazi Germany? It might seem, because of our rights-embedded culture and consciousness, which Leroy Reinweb has talked about, that there is no comparison. Yet rights vocabulary and institutions left unguarded are no more a defense against bigotry than other vocabulary and institutions. Any ideology, whether secular or religious, when manipulated by would-be violators, can become an ideology of death. William Shakespeare in The Merchant of Venice said the devil can cite scripture for his purpose. Equally, even a human rights violator can quote the Universal Declaration of Human Rights or the Geneva Convention for the Protection of Civilians in Times of War. Yesterday, it was Christianity which was corrupted into anti-Semitism. Today, it is the vocabulary of Islam and human rights which are similarly corrupted. Anti-Semitism continues, to be sure, with a modernized vocabulary. Instead of, and in some cases in addition to the protocols of the Elders of Zion, we have the claim of an all-powerful Jewish lobby. Yesterday, the pulpit, the Christian church, its lay organizations were institutions from which Jews were attacked in the name of Christianity. Today, it's the United Nations and the secular non-government organizations which attack the Jewish state in the name of human rights. Yesterday, Jews were accused of killing Christian children to use their blood for the baking of matzah. Today, the Jewish state is accused of grave violation of human rights and humanitarian law, of occupation, settlement, apartheid, denial of a right of return, disproportionality, and collective punishment. Yesterday, Jewish merchants were boycotted. Today, merchants selling products from the Jewish state are boycotted. Oral Braun and I, as you've heard from Oral, have both lived through the experience showing democracy promotion can be subverted to promote its opposite. I as a board member and he as the chair of the board of the government-funded agency Rights and Democracy. That agency, without disclosure to the board, funded 3 NGOs, Al Mazen, Al Haq, and B'Tselem, to produce research on the Gaza conflict, which claimed that Israel had committed a wide range of human rights violations for, in reality, what was nothing more than self-defense efforts against Hamas attacks. This research in the short term bamboozled Richard Goldstone and became the backbone of a one-sided report of the UN fact-finding mission on the Gaza conflict. Goldstone later, when he got hold of the real facts, and he was the chair of this report, eventually repudiated the report under his name. The manipulation was bad enough on its own. It turned out to be, though, the tip of an iceberg. Subsequent investigation showed a widespread pattern in the agency of anti-Zionism by stealth. The agency was working actively and secretly for years in a wide variety of ways to undermine the right to self-determination of the Jewish people. The reflex solution of bigots since time immemorial to the problems of our planet is kill the Jews. Though it starts with the Jews, it never ends with them. Are we on the verge of yet another mass violation of the rights of the Jewish people? A question we've heard from the floor. If we listen to the blood-curdling rhetoric coming out of Iran and Hamas and Hezbollah and the failure of the democracies to do all in their power to combat it, we can be forgiven for fearing that the answer to that question is yes. Yet even if we put the propaganda of Iran and Hezbollah and Hamas to one side and focus only on what is happening here in Canada, in universities and libraries, in the postings from Canada on the internet, in the offices of our attorney generals, in the halls of our parliament, it's hard to say that we're doing all that we can to stand against the threats our democracy faces. William Faulkner, in his novel Requiem for a Nun, wrote, "The past is never dead. It's not even past." The democracy of the Weimar Republic looms in front of us, yet we do not see it. We must. Thank you very much.
Thank you, David. I want to thank, on behalf of everyone here, our panelists for a stimulating discussion. Has given us much food for thought. There is some food upstairs, so literally and figuratively. So I do want to take this opportunity not only to thank our panelists, but to thank everyone who have attended. I hope the discussion will continue upstairs. We do have a reception in the upper barristers' lounge on the 3rd floor, and there will be people here, if you're not familiar with our building, that'll direct you there. I will ask that you fill out very short evaluation forms so that we can get feedback about the program for our future programs. And we'll see you upstairs in a few moments. Thank you very much.